All rise. Hear ye, hear ye, hear ye. The Florida Supreme Court is now in session. Let all who have cause to plead draw near. Give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, your Florida Supreme Court. Please be seated.
Good morning. Welcome to the Florida Supreme Court. The first case on today's docket is in re amendments to the Florida Rules of Judicial Administration Parental Leave. Please proceed.
Good morning, Your Honors. May it please the Court. I am here today as the immediate past chair of the Rules of Judicial Administration Committee and as one of its current members, and I'm here in my personal capacity presenting the position of the majority of the committee in this case, which was opposed to the adoption of the proposed rule. The first thing I guess I want to talk about as an initial matter is that the committee throughout this process has always recognized the importance of parental leave and has been very supportive of the granting of continuances for parental leave. The issue that the committee has is not with parental leave or the granting of it, but rather with the proposed rule which would make it mandatory to grant continuances for parental leave and would take away the discretion from trial court judges.
Mr. Sanchez, I don't think that anyone doubts that the committee and everyone feels strongly about parental leave and how the importance of that, but we understand that we're here on a rule change, and the rule change would affect the entire Florida bar, not just those who are parents. So the question I have is, right now the way the rule is structured, would a client be required to consent to the request for continuance?
I think it's unclear from the rule the way it's worded in itself. It does not say that, although I think the committee has always believed that in terms of the movement, there would not be a lawyer who would be filing without the client's consent, but there are those who have commented who have said that there is some lack of clarity with respect to that.
Well, the rule seems to, the proposed rule seems to suggest that it would be mandatory. So if a client did not consent, would a trial court still be required to grant the continuance?
Under the plain language of the rule, I think they would. I think the issue would be whether the lawyer ever files it, but I think once it is filed under the plain language of the rule, I think the court would have to grant it unless there's this showing of substantial prejudice.
And then is there, it's unclear to me, but under the proposed rule, is there a definition of continuance? Is it a continuance of trial, a continuance of a evidentiary hearing, a continuance of discovery?
There isn't, Your Honor, and that has been one of the committee's concerns, is that we don't know what it is. There's going to be this presumptive 3-month continuance, and then it could be, in some cases, a stay effectively of the whole case for 3 months.
Because the presumption is 3 months. The presumption under the rule is 3 months.
The presumptive maximum, yes. The request could always be for less, and the request could be for more as well. The rule does allow for there to be more time as well, but I think that is not within the presumption.
Now, is it, and I'm going to ask the same question to both sides. Is it your understanding, if a trial court judge were to deny a motion under this proposed rule, what would be the appellate review?
I think the appellate review would be as it is now. It would be probably certiorari review.
And is that I mean, for my time on the third?
Realistically, I think it's probably unreviewable for practical purposes, and that's one of the things that I think the committee has thought is that there are other things that should be considered in this process, because the parental leave continuance issue is something the committee believes is a problem, and one of the things that could be viewed at, we did not look at as a committee because it's not within the scope of our rules is whether or not that there would be some remedy of seeking some further review or facilitating that.
Would that be rule, if there was a rule change to interlocutory orders, that would be a rule of appellate procedure?
If it were done that way, yes. It could be something administrative, perhaps, where even some other judge on the court that's hearing it would just have a second look at it. I mean, those things have not been looked at, but that could be something. Basically, a check on the exercise of discretion, if you had it the other way, for circumstances like parental leave, and for others, because there are other personal circumstances that lawyers encounter.
Right, because right now this is just parental leave, but there's other issues. There's cancer treatments, a spouse has died, a parent is ill.
Yeah, exactly, Your Honor. And that is one of the concerns, again, of the committee and of some of the commenters, is that this elevates and addresses only one issue, paramount over others, does not allow a court to balance and look at all the different factors and consider other things that may be in place. And it may not be lawyers, it could be parties, it could be witnesses, it could be an expert in a case.
I know that the committee has looked at this issue, or I don't know how in-depth the committee looked at it, but in terms of education of not just the bench, but also the bar, because obviously opposing counsel, if opposing counsel is opposing someone who is moving for a continuance, who's about to give birth, or they're giving birth in a week and it's a civil trial and they have to do a trial and they're opposing it, did the committee look into education of both the bench and bar?
Well, the committee at one point wrote a letter to this court and to a number of others. I think it was the Conference of Circuit Judges, the Conference of County Court Judges, and I think, I remember Judge Salter in some capacity that he said to, I want to say maybe it's some quality, I don't remember the name of the committee, but, and basically suggested that there be some additional training for judges. I don't think that we did a formal request like that to the bar itself. I think there's been communications to do that, and I think that there's been programs put on by voluntary bar associations and things, I think, to educate and to address this issue, but the committee did not do that. Again, our role as a committee, and the way we viewed it, is to look at what falls within the scope of the rules of judicial administration. So we don't really have a broader authority than that. So most of it is just thoughts that we've had, some things that we've talked to other folks and done. Another one that's been considered is whether or not, and I don't know about this much, but whether or not the judicial canons and the bar ethics rules could be addressed. There's provisions that talk about not discriminating and against lawyers for a variety of reasons, not doing things like that, and parental status and pregnancy are not among those that are included, although there's many others, and those are potentially things that could be looked at as well to help address this issue and to make it easier for courts and litigants to push this. But the concern really of the committee has been not that this isn't an important issue that needs to be addressed, because it is.
In fact, Mr. Sanchez, if I understand the opponent's position correctly, I think, am I correct that the opponents agree that under the circumstances where a request for continuance for parental leave is granted in accordance with the rule at the right time, they don't wait till the last minute and all that, that a judge should exercise their discretion by granting the leave, correct?
Yes, I think the committee believes that probably the vast majority of circumstances where the parental leave is requested should be granted.
Can you think of a circumstance where it should not be granted as long as there's not substantial prejudice to the other side, as long as it's been requested as soon as they knew about the hearing or the condition? Under those circumstances, can you think of one where it shouldn't be granted?
Well, and I think part of the difficulty is with the rule is that it's hard to figure out every circumstance. You don't know what may come out. Some of the examples that have been given, one of the anecdotes is a case, and there's another one recently that's been in the press with someone who's undergoing cancer therapy, but it is when a lawyer has come into a case newly retained, very late in the procedure, trial's already set, and they already come in with that conflict. In other words, someone who's about to go on maternity leave enters a case, shortly before, and the leave is coming up, and the courts have denied it in that circumstances because everything's already been in place. And basically, I think in those circumstances, the notion is not so much the lawyer as the party cannot retain someone to enter the case at the late stage that already has a built-in inability to meet the schedule.
Well, what if you also have a witness who is a crucial witness, and the witness has either an illness or something that would prevent them from testifying at a later date and time?
Well, sure, but correct, Your Honor, I think that's, and where we get to substantial
But right
prejudice.
now, there's no discretion in the rule for the trial court to sort of figure out whether
No.
or not this is something that needs to give or not give.
I think that's correct. It's also very difficult the way the rule, I think, is phrased to know exactly what is substantial prejudice in this context. And the rule sort of builds in that some prejudice is okay, which is a little bit odd in the context of an attorney being able to subject a party to some level of prejudice. And I think that is something that had concerned the committee as well, is the fact that it's putting the lawyer's interest above what a party to some level of prejudice. And exactly what that dividing line is very difficult to know.
You have now exhausted all your time plus a minute and a half. We helped you. So I will afford you a minute of rebuttal at the conclusion.
Okay. Thank you, Your Honors.
I didn't know if that meant my time had been
No,
used as well.
you have separate time.
Thank you.
You have 3 minutes.
May it please the court, my name is Ted Green, and I'm here opposing the rule. To be clear, I don't oppose pregnancy or parental leave being a factor in someone getting a continuance of a case. I think a continuance ought to be based on the cumulative factors on both sides. I say both sides, the moving as well as the non-moving side in pregnancy, or someone coming into the family, say a father wanting time for an adopted child, is, I think, an appropriate thing for trial courts to consider. But I oppose this rule because, for 3 major reasons. It shifts the burden to the non-moving side to show that a continuance shouldn't be granted. I think that is distinctly un-American. If I'm asking for relief from the court in any way, it ought to be me that meets the burden and shows that it's necessary. It also takes, this is the second thing, it takes discretion away from trial courts. I said in my letters to the court that I've had the great pleasure, and it has been a great pleasure, to litigate all over the state. I'm a solo practitioner, but I affiliate with a couple of larger law firms, and the opportunities I've had to be before this court before, and many trial courts all over the state. I have found that trial judges in this state, for the most part, get this and everything else right. I'm not saying they get everything right, they're human beings, but I would guess, and I haven't seen any statistics from the other side, but I would guess only about 2 or 3% of Florida's trial judges get this substantially wrong. And yet for that 2 or 3%, and I'm guessing they haven't shown a percentage that are getting it wrong, that for that 2 or 3%, we're adopting a rule, or at least that's the proposal, that would hamstring the other 97 or 98% from using their discretion. Additionally, I have 3 very hard objections to the proposed rule. The first is, the very first sentence of the rule says that a lead attorney on the other side, the moving side, can request a continuance. My problem with that is it doesn't say the lead attorney. Now, attorneys parse language all the time and argue with trial judges that this gives me the grounds to continue the case. I do plaintiff's work. So when I go to trial, I'm usually the one person sitting over here with my client, but it's not uncommon to see 3 or 4 attorneys on the defendant's side, because my practice, we sue a lot of automobile manufacturers, for example. It troubles me as a plaintiff's attorney that I could prepare for trial, be ready to go, have a client who maybe has suffered damages that are hurting them, and now the 3rd or 4th string attorney on the other side, because of pregnancy or other reasons, is seeking a continuance. And in fact, their own examples show that there are 3rd chair attorneys that are basing their pregnancy as the substance for the motion to continue. So my first is, it doesn't say the lead attorney, it says a lead attorney.
You've used your 3 minutes. I'll give you another 30 seconds or
Yes,
so
sir.
to sum up.
There are two other reasons, one of which Justice Lawson talked about something that is important to me. He said, is there any reason it shouldn't be granted absent a showing of no substantial prejudice? This rule actually allows a continuance even where there's substantial prejudice, because my third objection to it is, it says that if the party opposing the continuance makes a prima facie demonstration of substantial prejudice, the burden shifts to the movement to demonstrate that the prejudice caused by denying the continuance exceeds the burden that would be caused by the objecting party. So in this rule, we actually have a way of getting around substantial prejudice to the non-moving side by simply convincing a court that, well, it's more inconvenient to me than it is to the injured plaintiff, for example, in my scenario, is what I do. So this rule is overbroad and unnecessarily hamstrings trial judges. I'm not saying the situation shouldn't be addressed, but not in this way. Thank you.
Thank you.
Good morning. May it please the court. My name is Susan Warner. I'm here on behalf of the Rules of Judicial Administration Committee minority position. The court should adopt this rule because it will protect clients and provide legal clarity in this issue to judges. One of the first points I want to address is raised by Justice Lagoa, which is whether a client still has to consent to the continuance. And it's a minority's position that yes, like a consent by the client would still be required. The general continuance rule does still apply. I think if the court thinks that's unclear, they could add some language to the proposed rule that would make that crystal clear that a client consent is still needed. And for that reason, that is why this rule protects clients' interest. Because if an attorney is coming into court and requesting a continuance, that is with the approval and consent of their client. That is that client telling the court, I want my attorney.
What if the client opposes the motion?
I think if the client opposes the motion, then the continuance couldn't be granted. That would be either.
Well, let me ask you a question. Obviously, parental leave, I believe, is obviously important. But the question I have is, why just put parental leave as the sole issue when there are other issues? I mean, I know of situations where a spouse has died and a judge requested that the attorney still appear in front of court in order to argue a motion, or other situations where someone's receiving cancer treatment and they need a continuance. I mean, I understand the situation of, and it's horrible to have someone say that you have to be at trial a week after giving birth. No one should do that. So the question I have is, why limit the rule to just parental leave? Why should it not just be an emergency family situation?
Because we haven't seen the same systematic statewide problem with the opposition and denial of continuances in those other situations. What we have seen and what we've heard from the members of the bar is that opposition and resistance to continuances based on parental leave continues to be a problem across the state, as demonstrated by even the most recent filing by Fall, showing that this is a problem that still continues to occur, even in the face of 3 years of a much more robust and publicized debate on this issue.
Well, the filings by Fall didn't really necessarily provide the years that these issues happened. I mean, I understand that there are issues that are still happening, but that to me is important. And also, there are judges who are doing the right thing.
There are judges who are doing it. In the most recent filings, though, the supplemental filing that was filed last week shows this was what's happening up until last year, and I think still continues to happen throughout this year. It's difficult to have.
Well, let me ask you, because even if we pass this proposed rule change, what would be the appellate remedy? Because from my perspective, I think that that's really one of the issues that is relevant here, in terms of if a trial court judge believes that they're going to have an appellate issue, and that this may be something that would go before an appellate court, before a DCA, perhaps they would think twice before ordering someone to trial after giving birth.
I think that would be probably the practical effect of the rule. I think the remedy in the case of a denial would be the same as if a continuance was denied under the regular continuance rule, which would be to petition for cert from the court. There is case law that says that is an available remedy.
But
if
you
a
know,
continuance-
petition for certs are very difficult.
They are very difficult. I think with a new parental leave rule, it would give more legal guidance to the courts, for even the appellate courts, of a legal standard that a.
But can't we do that by amending a rule of appellate procedure in terms of what could be appealable?
To exclude the parental leave rule, or to include?
If we did something where you do a motion for a continuance that was denied for an emergency basis, like not just parental leave, but an emergency situation involving medical treatment, a family emergency.
I think it could be addressed in that manner. I think for the committee, the minority committee's position, they would welcome any action from the court to address this issue for the state. We think a rule is the best way to do it because it provides the force of a rule of law, something that judges can look to and rely upon, that other attorneys can point to when both they need to request a continuance on this basis, or if you need to tell your client on the other side, look, we can't really oppose this because here's this rule.
I know that your time is up, but let me ask you a quick question. For purposes of continuance, the rule it's undefined as to what a continuance means. And do you not believe that a 3-month automatic stay, in essence, let's say at the moment it's not a trial, but it's an issue where discovery is still ongoing, an automatic stay of 3 months for discovery seems like a long time?
I don't necessarily agree that it would be a long time, and the rule does not require that it always has to be 3 months. That is the presumptive max. I would also argue that continuances are not defined specifically in the regular continuance rule. It just says continuances. It doesn't specify only for trial or for these evidentiary hearings.
But normally when someone's filing a motion for continuance,
Yes.
Ms. Warner,
Yes.
it's for trial. I
Right.
mean,
And I think even under the parental leave rule, that still would apply, that I think generally this would apply to a continuance of a trial, I think it could be applied to an evidentiary hearing. I think depending on the circumstances, a 3-month stay or a 3-month continuance of the case is not unwarranted to afford that litigant the right to have their attorney who's invested in the case, who's prepared and knows it, represent them in court.
thank you.
Do you mind if I ask one quick question? Sorry. I just wanted to see if you could respond to something that Mr. Green raised, and that is if you could give us your sense of what the term lead attorney means and what you would think of changing a lead attorney to the lead attorney.
I will first say that the term or lead was inserted into the rule as a compromise in discussions over this rule because there were some concerns raised, I think echoed by what Mr. Green said, that somehow firms would use this to sort of game the system, and so the lead was inserted as a compromise. I would argue that if lead is left in, lead would mean an attorney with primary and substantial responsibility in the case. I do not believe a third, fourth chair associate who hasn't taken depositions, appeared before the court would be someone who could be considered a lead. That being said, I do agree if the court has an issue with that term, the minority position is we'd be perfectly fine with taking lead out of the rule and just having it say an attorney, and leaving that discretion with the court.
The question is, would you be perfectly fine saying the lead attorney?
No. I think because what will end up happening is I think the term lead attorney already we've seen in some of the more recent oppositions to continuances is that parties will use that, or other attorneys will use that term to try and diminish a woman, particularly this happens to women, their role in a case, kind of portraying them as not really the lead attorney because maybe they don't have the most senior years of experience on the case, even though they're the ones who are the client contact, they've been taking all the depositions, they've been doing the witness interviews, they've done all the motions. So I think saying the lead attorney also implies that there's only one attorney in any case who could ever be running the case, when the practice of law is sometimes there are 2 lead counsel who are both equally responsible for the matter. Any more?
Thank you.
Okay, thanks.
May it please the court, I am Laura Bach, representing the Young Lawyers Division of the Florida Bar that voted unanimously in favor of the proposed parental leave rule. Across the state, our constituents have told us that this is a problem, which is why we support the rule, and we hope that it will be adopted today. But they've confronted significant opposition from opposing counsel and even the judiciary. In fact, a number of appalling examples are cited in the court filings that are before Your Honor today, such as, one woman whose request was scheduled on the day of her C-section. That should not happen in courts in the state of Florida. And this rule is designed to address those injustices that are happening and to also, as my colleague said, protect the client's interests.
Wouldn't a rule, as Justice Lagoa suggests, an interlocutory rule for appellate review suffice for addressing this?
I think it's possible. It's a great suggestion. I think the problem is that it might not prevent where the injustices are occurring are at the trial court level. And so while that may, discourage some because they're considering the appellate review.
It seems like this rule anticipates that a judge is going to do the wrong thing. And it tries to keep a judge from doing the wrong thing, expecting that. But the way our judicial system works, it seems like our rules, when a trial judge makes a mistake, the way we remedy that in our system is on appellate review. So it seems like an interlocutory, not a cert review, but an interlocutory appellate review may be appropriate to address a trial judge who really does make an erroneous ruling of some kind. Would it not?
The impact of these mistakes are so great, and perhaps that would give them quicker review.
My issue with this proposed rule is that your assumption is that even if we pass this proposed rule, that a trial court will follow the rule. And the problem is that that's not necessarily so, because that's why appellate courts exist.
Right.
So if a trial court does not follow this rule, what is the appellate remedy? Because there isn't one. And so it's sort of like...
Right, but what's helpful in the proposed rule is that it requires the court to enter a finding. And currently there is no requirement to do that, so it's difficult to seek, to petition for cert. But when you have a finding written out by the trial judge, it makes the petition a little bit easier, right? You can give them a basis.
But the issue is still petition for certiorari is a very difficult hurdle to meet. And so to me, the true remedy for this would be really an interlocutory order or an appellate procedure change, rule change.
I think we'd be amenable to that as well, but we would still submit that the rule itself is necessary to shift the presumption in favor of parental leave, because we see still today many examples of parental leave not being considered good cause for a continuance, and perpetuating, really, I also want to touch very briefly on the impact that this rule would have on, an issue that's plagued our profession for many years, which is gender bias. We have women are not that often lead counsel. We are underrepresented in, firm partners as well as judges, and this rule could have a significant impact on that, because right now they're being treated as they can be sidelined in the cases and marginalized and simply replaced and assigned with a new attorney. And it's not that simple, especially for solo practitioners, which I believe represent approximately 33% of the Florida bar. They may not have someone else to assign that case to.
Is that the reason why this is not limited to, or not expanded to, just family medical leave, but instead is focused because of the historical issues with gender bias in the profession and the bar?
I think it's certainly a positive externality of this rule, and it is certainly something that the minority has commented on, the impact that it can make.
In other words, has there been a 100-year history of discrimination against cancer patients?
Right, no, right. There isn't. And again, our constituents aren't telling us about issues with being denied continuances on the basis for cancer treatment, but they are telling us that this is a problem.
I can tell you that in fact is true.
Yeah, no, I believe, Your Honor, that it's happened.
There are situations, which is why when I was on the 3rd District Court of Appeal, our continuances were freely granted because we had a judge whose wife was undergoing cancer treatment, and she was denied an extension and a continuance at the 11th Circuit. So it happens.
Right.
So it may not be whatever, but I'm not necessarily sure that there's been a survey that's gone out to different bar members about this issue, about whether or not they've had issues that have been also denied on behalf of health issues.
And perhaps there should be a rule for medical emergencies, but for right now, and what's, before the court, it's the parental leave rule because it's been raised to us, but perhaps this is something we could consider as well.
I apologize for interrupting you. Can I just ask one quick question?
Yes, yes.
Because you're a little bit over your time.
Oh, sorry.
If it gets to the point where the court is having to balance prejudice versus prejudice, the rule is clear that on the one side it's substantial prejudice to the party that's opposing the continuance, but on the other side, is it prejudice to the attorney or is it prejudice to the party that the court would be looking at?
I think they'd be looking at a number of different circumstances. I think the comments note to the rule that they'd be, can be denied in the discretion of the court where there's prejudice to the party, where there's an emergency or time-sensitive manner, when there have been a number of continuances already requested in the case previously. These are all considerations, and I don't think there's a limit to the considerations or factors that the trial court would consider when they're weighing the prejudices.
But isn't at the end of the day, the litigation, the interest, the paramount interest are the client's interests? Because it's the litigation that belongs to the parties.
Correct, I agree, but
So shouldn't a substantial prejudice, the first burden be whether or not the clients are being prejudiced?
Well, I would surmise that the client whose lead counsel is going out on parental leave is being prejudiced by not having that attorney able to represent them for critical proceedings. Thank you.
Thank you.
May it please the court, Jennifer Richardson here on behalf of the Florida Association for Women Lawyers, also known as FAW. The rules should be adopted. Parents need it, judges need it, parties need it, and babies need it. The mission of FAW is to advance and promote gender equality in the legal profession, the judiciary, and the community at large. This rule certainly involves all three stakeholders, as Justice Lagoa points out. Legal professionals who are parents need certainty. When their clients and their employers and even their opposing counsel agree to a continuance, they should have confidence that the court will grant it. Judges completely maintain their ability to deny continuances. They simply must make a finding, which we do believe will assist in the availability of cert relief or the availability of even appeal on final appeal, as rare as it may be. The rule promotes efficiency and consistency by giving all involved stakeholders and the judge the ability to understand the likely result whenever a motion like this is filed. The rule certainly serves the community at large because it allows clients their choice of counsel and babies time for development. The advancement of women as professionals is directly implicated by this rule and by these denials. As this court knows, an application for board certification or judicial office or even a request for proposal to obtain a serious litigation, all of those applications ask for how many cases you have handled as lead trial counsel. One issue, aside from the impact on the stakeholders, is that many times I think the assumption when a continuance is denied is that the client will get different counsel and the case will be tried. If you look deeply into the examples, that's oftentimes not the result. Oftentimes the result is that the client who wanted to take their case to trial settles out of court because of that decision. I'll close by saying that even if this court decides not to adopt this rule or decides to adopt a different iteration of a different kind of rule, all of these stakeholders need a writing and a guidance from this court, explaining that it is our expectation that these continuances will be granted and will not be denied by professionals and jurists in Florida in the absence of substantial prejudice. Any questions?
I do have one. I don't think we've ever done this before, but what would you think if, everybody recognizes that we have a serious problem that causes serious problems for the practitioners in this state and their families. And everybody seems to suggest that we should do something is needed. And we've already punted once and haven't done anything because what was proposed had problems. There are potential problems with the rule as drafted. What would you think if we adopted this or something similar to it with a sunset provision that would automatically go away in X amount of time, but with opportunity for everybody to come back after we've had some experience under the rule to see if it really is problematic. I mean, that, and then maybe there would be tweaks or something like that, but I mean, projecting this unknown of, well, there could be problems, when we know we have problems now and not doing anything, what would you think about that, a sunset provision in a time to get some experience under the rule and then have everybody come back and say, this really isn't working, we need to get rid of it altogether, or we need to...
I've certainly not seen that done before, but this court is the master of the rules. So I think that that is a creative solution, and we should be creative about how to address this issue. I think that would be helpful. It's extremely difficult to get data on this issue. First of all, there's reluctance by attorneys to come forward and share their experience of denial. And look, this is never going to be presented as a pie chart to this court. That, you know, X number of percentages are denied.
Well,
we don't keep those kinds of statistics in the court system.
Let me ask this, sort of following up to Justice Lawson. The current rule for continuance, which is a civil procedure rule, 1.460, doesn't have the language about a written order. What if that was added to that provision, which says if there's a motion for continuance there, the court shall enter a written order setting forth in the ruling on the motion, and if the court denies, you have to give specific grounds.
That would be extremely helpful for appellate review. I know, of course, the court has to consider.
It still allows for discretion.
It
but
does.
It would require a trial court judge to give a written reason why it would be denying.
It would be very helpful, I think, especially on that departure from the essential requirements of law prong. We could address it better if we had a written finding or an order to appeal.
Thank you.
And that could address all of the concerns that Your Honor has raised. Further questions? Thank you.
Not yet.
May it please the court. My name is Michelle Browning-Coughlin. I'm the founder and president of Mothers Esquire, and we request the court adopt the proposed rule. Mothers Esquire is a national network of thousands of women attorneys who are also mothers. Our mission is to remove structural barriers to women lawyer success in the profession, with a particular focus on addressing unconscious bias towards mothers. One such structural barrier is the lack of parental continuance rules. In January, the American Bar Association adopted a resolution urging all courts across the country to adopt parental continuance rules. The ABA resolution report underscored that denial of parental continuance motions adds to the list of obstacles that women lawyers face. Notably, when these motions are denied, the impact is often that a woman is required to hand off her cases to someone else, setting in motion a series of events that can lead to other career obstacles, including unequal pay and lower quality work assignments. Not only does the lack of such a rule prejudice her client, it can create a figurative brick wall in her career path for years to come. And men, too, are harmed by the lack of this rule. The benefits of paternity leave cannot be overstated. Men deserve better than to be treated as if they are second string in their role as fathers. The proposed rule is gender neutral for this critical reason. While Florida can show great national leadership by adopting this rule today, you're not alone in considering such a rule. In Texas, the State Bar Rules Committee has drafted a parental continuance rule, which has been submitted to the Supreme Court Advisory Committee. And in my home state of Kentucky, a coalition of women lawyers groups is working to draft a rule to submit to the Supreme Court, patterned after Florida's proposed rule. The thousands of women lawyers in Mothers Esquire across the country are watching today. And on their behalf, I ask your honors to adopt this proposed rule to remove the systemic barrier for mom lawyers and dad lawyers across Florida, and to remove this brick wall in their path. Thank you.
Chief Justice Kennedy, Justice of the Florida Supreme Court, may it please the court. My name is John Stewart. I'm the president of the Florida Bar, and I'm here on behalf of the Board of Governors. The Board of Governors of the Florida Bar has recommended the adoption of the parental leave continuance rule unanimously on 2 occasions. The unanimous recommendation includes the rule pending before this court today. The rule as proposed advances the bar's missions, 1, in promoting diversity and advancement of the diverse professionals in our profession. 2nd, the rule as proposed advances the bar's mission to encourage health and wellness and to encourage work-life integration as physically and mentally healthy lawyers better serve their clients. And importantly, as has been addressed, this rule advances the best interests in putting the clients and the public first and assuring that they get the lawyers of their choice. I would commend the concept of Justice Lawson to this court's attention. I believe that while no rule is perfect, not doing anything is also not perfect. Sometimes perfection is the death of progress, and we need progress in this arena. I think a pilot program in order to establish data and metrics will help this court in assuring that whatever rule is passed is appropriate for the lawyers and the citizens of Florida. So respectfully and unanimously, the Board of Governors requests that this court adopt the current pending parental leave continuance rule. Thank you, Your Honors.
Thank you.
May it please the court. Thomasina Moore for the Guardian Ad Litem program. Time is the right of the child. As the RS Court tells us, by adopting that provision through Section 390136, the Florida legislature has assumed principal control over the issue of continuances in dependency proceedings through statutory law, and have set the time to permanency and the child's best interests as the guiding factor for the dependency court. Just this last legislative session, the Florida legislature reaffirmed that commitment to that principle by enacting a year is a long time in the life of a child act, which makes continuances even more strict in dependency proceedings. By inserting language in the proposed rule, which states that a trial court should exercise its discretion to reasonably accommodate parental leave rule requests, the rule in effect reverses the order of preference that the statute has set by putting the focus on the attorney rather than the child. And it is for this reason that the Guardian Ad Litem opposes the enactment of the rule as worded. And we would request that if it's enacted, that last sentence be stricken. There's sound public policy for restricting continuances in dependency proceedings. Consider the Regis Little Act, which in revised Section 39701.
Counsel, doesn't the proposed rule specifically state that it has to be subject to statutory and rule requirements that are currently in existence?
It does, Your Honor, and I struggle with that, candidly, and I cannot think of a time that you would have discretion other than to consider the timeliness to permanency, because that's the overriding principle of the statute. But by inserting that language, it kind of muddies the water of when they may have discretion and what their overriding principle should be.
But if it's subject to other rule sets for juvenile and for certain other rule sets and for other statutes, mustn't whatever's in the rule give way to what's in those statutes and other rule sets? Isn't that exactly what that language means, or why it was inserted in there?
It does, and as I think Ms. Warner indicated, there was a lot of compromise language which was inserted in there. However, I don't think compromise language should be inserted in a manner which can be interpreted as diluting that principle, which is the child's best interest has to control. There are very sound reasons for having that language in there, and as I was starting to say with the Regis Little Act, that was enacted so that a trial court would have the ability to impose a guardianship for a child with a disability within the last 6 months of the case pending. With Regis Little, no such guardianship could be imposed, and within just a few weeks of aging out, he was killed in a fight over a single beer. If we had continuances within that 6-month time frame between 17 and a half and 18, that could very well prohibit the court from establishing that guardianship. And to say that these can have life and death consequences for these children is really not overly dramatic. And so for that reason, the Guardian Ad Litem, in the best interest of the child, would act that the court just simply exempt us from any rule that's pending and allow the statute and the rule of juvenile procedure to control.
What rules govern dependency proceeding? Isn't it the rules of juvenile procedure?
Yes, it's Section 3 of the Rules of Juvenile Procedure.
Doesn't subsection B of the proposed rule exempt?
It does have that exemption language, but it's followed immediately by the next sentence, which says that the trial court should exercise, which seems to somewhat dilute that exemption and say that, you know, you're exempt except the court should. We did consult with certain, with dependency court bench and asked them if they thought this would be confusing and difficult in application, because they did seem to have this directive and they did agree that it would be, at least the people that we talked to. We didn't do a complete poll.
Okay.
Maybe if that was moved up above the exemption even, then in not following it, it might clarify that it's not intended to apply in that instance.
But your concern would be addressed by...
It says that in proceedings governed by the Florida Rules of Juvenile Procedure and others, they will be governed by these other rules and not by this rule. I mean, I don't know how.
But you're saying that the
You're saying
should exercise any discretion. It sort of implies that there's, but we know it's this, but maybe there could be some discretion for you to.
Yes, and in particular, with application of the rule being in the rules of judicial admin, which are more broadly applicable. So yes, that's exactly.
It's creating, it would create confusion is what you're
We
saying.
believe it would, or at least has the potential, and there should be no cases in which a child's permanency should be delayed because of confusion in reading the rule.
And you would have no problem with the rule if that last sentence were taken out?
No, we did also have some concern with the language regarding a lead attorney. In the manner in which we assign cases, we often switch out. We have to cover for one another. There's a lot of change. It's difficult to identify in that process who a lead attorney would be. So we had made a suggestion, and I believe Mr. Silverstein will address more in depth, to take that provision out. And the rule of Juvenile Rules Committee agreed.
Thanks.
No further questions. Thank you, Your Honor.
Morning. May it please the court. I'm David Silverstein. I'm the former chair of the Juvenile Court Rules Committee. Our committee, of any committee, is sensitive to issues involving the family, including parent-child bonding. Our committee consists of practitioners who are dedicated to make the juvenile court process better for children and their families. Our committee believes, however, that issues involving continuances should be left to the discretion of judges governed by existing law to prevent delays in dependent children achieving permanency and delays in resolving children's delinquency charges. In particular, the dependency statutes require that children should achieve permanency as soon as possible and no longer than 1 year. The statute was designed to prevent children from suffering trauma from not having permanent homes. Section 39.0136 provides that the time limitations in Chapter 39, the dependency statute, are a right of the child, which may not be waived, extended, or continued except as provided in the statute. Delinquency rules require that children have a right to trial on their charges within 90 days. Why? Because children should not have charges hanging over their heads indefinitely. So the Juvenile Rules Committee applauds the efforts regarding parental leave. We have strong feelings about it, but we are directed by the law, which says that the child has the right in delinquency and dependency proceedings regarding continuances. However, the Juvenile Court Rules Committee believes that if the court wants to create a parental leave rule, we, of course, you've identified that juvenile rules cases are exempt from this rule. So we are fine with that. However, our committee is not fine with the term lead attorney. There is no definition of lead attorney in the proposed rule. This court declined to adopt this reference.
Well, that's an academic interest of the committee, because it doesn't affect because you're exempt from this, right?
Yes.
So that's more of a theoretical concern you have with respect to cases that are not within your scope.
Yes, Your Honor, because Juvenile Rules Committee had some strong feelings about the case that this court considered in 2017 concerning amendments to the Rules of Judicial Administration, Criminal Procedure, and Appellate Procedure, in which there were proposals to define these terms, lead attorney, additional attorney, and so forth. So we object, as far as our committee, to this concept of lead attorney, because it's not defined.
You don't want that concept creeping into our rule structure.
Yes, Your Honor.
Okay.
Any questions? All right, thank you very much.
All right. Now it's time.
Your Honors, this is an important issue, there's no question. The committee does believe that the court should act, that there's guidance needed, that the bar needs to do it. We just don't think that this rule is the right way to do it. There's too many problems.
I'm sorry for interrupting you, but because Justice Lawson asked a question earlier based on the premise that everybody agrees that the court needs to do something, and you just said something kind of similar to that.
Yes.
But could you be clear about but you're opposed to the rule. Could you be clear about what the alternative is that you think the court should do?
Well, I think there are other things that should be explored. I think the appellate review, some sort of check to see whether there's a problem. There's been comment made that it's a systematic statewide problem. It's not. That's not what this record shows. It is a continuing problem, perhaps, but it seems to be outliers that do it. Most of what's in the record is that most judges grant it appropriately, and most people are finding that that's what happens.
Is the majority position of RJA that a discretionary rule would be appropriate?
I think that a discretionary rule addressing only parental leave,
Yes, that's somewhat consistent with the general rule, but is specific to parental leave or family medical leave issues.
The committee was never that explicit on this. We had looked at some earlier things with discretionary. The committee had not been in support of some of that, had voted against it for different reasons. So I don't...
Counsel, there would seem to be three options. There's the mandatory provision in some form as we have now, as proposed before us. There's a discretionary provision that leaves discretion to the judge, which is similar to what we have now, but maybe tailored to this issue, or nothing. So which is it?
Well, I think the committee would say that the existing structure should deal with it in terms of continuances, and that the remaining issues should not be dealt with in the continuous rule, but should be dealt with through other procedural obstacles, through education.
Could you do a procedural rule change in terms of where you amend the civil procedure rule and the appellate procedure rules in terms of making the trial court judges explain in their written order why they're denying a motion for continuance under the existing motion for continuance rule, and then do an interlocutory order or an appellate rule change where those orders would be appealable?
That is something the committee did not consider. I believe, and this is just my personal view of the committee, I think that the committee would not be opposed to that. I think...
Because then you would have the metrics of what are the motions that are being denied, why are they being denied, and
yes.
Then we would have some statistics on who is denying and why.
Yes, and I think in terms of Justice Luck, your question in terms of that, I think the committee has always thought that this needs to remain a matter within the discretion of the courts, that they need to look at all the factors that appear in a case, that what may be appropriate in one case with one set of lawyers, with the history of a case, may not be appropriate in a different case. And that is what this rule tries to do. It tries to force everything into one thing. So I think the more you get into preserving discretion but making it reviewable, putting it in some situation, that is the sort of thing that I think the committee would support.
But what would, I mean, if it were more easily reviewed on appeal, but under a super discretionary standard, I mean, what would the appeals court even be considering?
Well, I think it would be abuse of discretion. And that's what we're really talking about. Some of the anecdotes that had been put forward, I think when you look at them, I think for most folks, and I think that's what they're saying, is they are abuses of discretion. I think that's what's being described. There are judges who are not weighing these factors and are abusing their discretion in denying this. Some of them, I think the anecdotes are that the continuance has been unopposed, and the judges still denied it. The requirement that someone, when they're in the hospital, have to file something, I think.
And so if the court, because I don't know that you agree that option 3 is doing nothing. I mean, you mentioned education. What would that look like?
Well, I don't, Your Honor, I'm got to say I'm not an expert on education putting forward, but I think it would be programs to make sure that folks are aware of the problem, put forward the statistics, put forward the information that some of the proponents of the rules have put out, making sure that judges and lawyers are aware of those circumstances, letting them know the impact of what's at stake when they do deny these things, when they don't properly factor in and give this issue the important consideration that it deserves. I think those are the issues behind the idea of educating both judges and lawyers on this issue.
All right, well, we thank you. We thank you all for your arguments today.
Thank you.
Thank you.
The court will now stand in recess for about 10 minutes.
All rise.